that forms the basis of their request to ask this tenant for that second doctor's note?
I'm not aware of it. Are you aware?
Well, as I said, she never did come forth to the office to register the animal.
Welcome to Group 5 Management versus Olivia Bell, where a $1,054 balance isn't rent, it's pet fees, late fees, and NSF charges. But the real fight, ESA rules after a replacement dog. The judge is already grilling management hard. Subscribe, like, share. More courtroom chaos coming fast.
The balance owing is basically stemming from pet fees and a pet deposit for an animal that Ms. Bell had. The question that's presented is the application of ESA. Back in 2019, Ms. Bell applied for an ESA for a dog, I believe it was a pit bull. She had a letter from her doctor indicating the need for the support animal, and it was granted. At that point in time, she did not pay a pet fee or a pet deposit. Subsequently, I believe in February of 2023, she had to remove the support animal because it was a pit bull and apparently had bitten one of the tenants. That was in February. She replaced the animal, and then in October of 23, we requested that she certify the new animal, which I believe is Pride Chihuahua. And
well, let me ask this, because what was I remember the issue, but the certification for the animal, however one wants to put that. Well, let me put it this way. Does the complex certify the animal?
The complex asked that she read certification that of her needs for the support animal, which in 2019 she did provide for us. We asked starting in October when she got the new animal, we asked that she recertify herself that she had a continuous need for that support animal.
Okay, and again, that I guess brings me to the next point. If nothing had happened with the pit bull, she wouldn't have had to recertify anything.
Well, we take the position that we could have asked her to certify, but we didn't. The fact that she had the replacement animal brought it to our attention. Does Ms. Bell still need a support animal? If so, we asked that she be recertified. We asked, and I have if I can present to the court, if I may approach, Your Honor.
What are those?
This is a thread of emails between Group 5, Group 5's attorneys who was handling the case then, and Nikki Green from Fair Housing, talking about the pet situation. And Nikki Green basically said she was going to follow up with her doctor, I think Dr. McAvoy, to see if we can get the certification. According to our information, Dr. McAvoy refused to do the certification. We asked that she possibly.
But was that the previous doctor?
Hmm?
Okay, but here's my issue with this. When she did that in 2019, she's not certifying the animal.
Correct. She's certifying her need for an animal.
Right. So what would lead the complex to think that changed?
Well,
Because and the reason I'm asking that is because based upon at least what's been represented to the court, the only thing that happened is the removal of the animal.
that brought it to the attention of management that does she still need a support animal? And that's why we requested certification.
Why would that raise the issue?
Well, I believe there's a difference between an ESA and a service dog. A service dog, if you're blind or
Right.
handicapped, you apply for a service dog. That's a different type of certification. And at that point in time, if it's granted, basically it's for life. Support animal is different. It's like,
Well, what explains to the tenant that it's different? I mean, because from what I'm hearing, and correct me if I'm wrong, in 2019 to 2020, in 2020, the dog is still there and she doesn't have to do anything. The dog just continues there. 2020 to 21, same thing. 2021 to 2022, same thing. So I'm looking at a 3-year period where she has to do nothing. She has this dog.
we didn't raise that issue at that point in time, but
Why, though? I mean, what makes not raising the issue at that time as opposed to raising it later on? What's the distinction
well,
if you're not certifying the animal?
I believe that in a situation that the complex has the right, and there's nothing in the law either way, that we have the right to certify, recertify, or we don't have the right to recertify. So it brought us to the attention, does Ms. Bell still need certification? And it's a simple process. All she had to do is go to the doctor.
Well, I get that that's the process that the landlord wants her to enter into.
Correct.
The problem that I'm having with this is why was the request made at that time as opposed to being made at every 6 months, every year, every whatever?
Well, the dog was, the pit bull was removed in February of 23. We waited 8 months. She got a new dog. We waited 8 months until October of 23 in order to give her some time to get the certification. At that point in time, we formally requested it, and that's when we started assessing.
But when did the new dog come in?
Excuse me.
When was the new dog?
I can tell you all of that real quick because my mother doesn't even really sure of it. Faithful was moved out of the house in April of 22, not 23.
Okay, that's fine.
In December of 22. You all got the wrong dates. I don't know why.
It doesn't, ma'am, I don't need that.
Okay.
If the dog got removed February, April, when did the new dog show up?
December of 22. December of 22.
Yeah, it was 8 months after the old dog was removed.
And then when was the request made for the new?
In October of 23,
So,
I believe.
so was that the first request for the
For
ESA?
recertification, yes. In October of 23.
So why did that happen then?
Why? Because at that point in time, we reviewed our records and we said, well, does Miss Bell still need the dog? And
So-
that's when
Whoa. No. I'm just trying to sort this out. Because this doesn't make much sense to me. The pit bull gets removed February of April, whichever it is, of 2022, right? The new animal comes in December of 2022, right? And the request for this is effectively a year later, 10 months later,
Correct.
by the landlord.
Yeah, I understand what this court is struggling with, but if you take a look at, comparable laws like workers' comp, not social security, or disability insurance, they have the right to review the continuing disability every so often, every 6 months.
But you're not reviewing her disability.
Yeah, by asking her for recertification, we're asking.
Where in the lease does it state you could do that? I mean, because
It doesn't.
That's the problem. The problem
We're dealing also with the law, Your Honor. The law is unclear on it itself. The ESA, fair housing, as it pertains to ESA, and I checked into it. There's no.
I get that. I understand the complexities or absence thereof. What I'm looking at the circumstances of this. So one thing that's very clear to me is had the pit bull remained, there wouldn't have been a request.
Maybe.
Well, there wasn't.
There wasn't.
Right?
Yeah. But
pit bull gets removed, a new dog comes in, and when the new dog's there still is no request.
At that point in time, no.
Then 10 months later, effectively, almost 11, really, I guess, depending on when in the month these things are occurring, 10 to 11 months later, there then is a request.
Correct.
And I'm trying to figure out why was that request made?
It was brought to our attention that does Miss Bell still need a support animal?
Brought to your attention by whom?
It was brought to our attention in the review of the record. A review of the record when we found out that she had the new dog, we asked that she recertify herself as a need for that support animal. And it's a simple, I understand the court, but it's a simple process. And according to the.
But why would you ask? That's my question. I'm not so much concerned about what the process is. I'm not concerned about what happened, didn't happen. Why would you ask?
It was a review of the records showing that she has a support animal. Does she need a support animal?
But hold on a second. When was the landlord aware of the new animal?
This is Kurt Herbeck. He's the.
When was, I just need an answer.
October.
October of what?
That's when she was first charged.
No, I'm not saying a charge. When does the landlord know she has this new animal?
I think it was sometime in 2023, according to the email threads I'm looking at. It was prior to.
It was several months after she removed the pit. She was observed with the Chihuahua, and that's when she was asked about it. She never came to.
That was 11 months after.
Yeah, but we didn't know that she had the Chihuahua at that point in time.
Is there a policy regarding this at all with the landlord?
Is there a policy?
A written policy? what places the tenant on notice that this has to happen?
We
Or
notify them.
Or you can't do that, Mr. Weiss. She's under lease.
I understand. The pet agreement. There's nothing in the pet agreement that references it, but it also doesn't reference ESAs in the pet agreement. So ESA is a part of the fair housing.
Right.
Okay. There's nothing in the fair housing. I understand.
I'm trying to figure out what triggers the landlord to ask. And, and with that, what places the tenant on notice that the landlord can ask and then needs to comply with something?
Well, they have to inform us that they have a pet. Okay. If they're claiming that they have a need to have that pet classified as an ESA, emotional support animal, they have to go through the procedures as set forth.
Okay, but that's apples and oranges.
No, I don't think so.
Well, it is, because she's not here because she failed to notify you of the dog.
No, she's here because
She's here, at least what the landlord's saying is because the landlord made a request for the doctor to indicate that she needed an ESA.
the continued need.
And what gives the landlord the right to ask her that once she has already given it?
At 19 minutes, the judge drills the core issue. What triggers recertification? For years, no yearly check-ins, then suddenly a request only after the pit bull's gone. That inconsistency matters. Courts hate made-up-as-you-go enforcement. Audience, should landlords need a written policy before demanding new doctor proof?
Under what authority is the landlord requesting that?
Well, as I said, the ESA has no law either way. As far as
Either way,
requiring
in terms of what?
of requiring recertification or not.
Here's the landlord's problem.
I know what the landlord's problem is.
If the landlord said, okay, every year, for those that have an ESA, every year you must recertify the need. Fine. Even if then there's a late request, the landlord has something to say, I can make this request. So the time period doesn't necessarily matter. But as I'm looking at this from what I'm hearing is, had the pit bull still been there, there would have been no request from the landlord to do anything.
Maybe.
Well, it's not a maybe. For the 3 years, 19, 20, 21, and 22, 4 years almost, that the pit bull is there, there's been only one request or one submission. They didn't ask each year.
No, but what
There's not even anything, Mr. Weiss, unless you can point me to something that says, okay, periodically we will request X. Is there anything that says that would place the tenant on notice that the landlord could make the request?
not that I am aware of right now, but if I can point the court before it makes a ruling, take a look at the email threads from Fair Housing and from Group 5 and Group 5's attorneys.
But what are those email threads going to do for me?
It would show that this was discussed. It was discussed with Ms. Bell.
Okay, I get it. I get all of that's discussed. just, and if necessary, I would take a look at them. What gives the landlord the right to do it in the first place? What gives the landlord the right to say anything that makes that discussion happen?
There's nothing that says that we can't ask.
Mr. Weiss, you can turn my question around all you want,
I know.
but it doesn't get you anywhere.
I used to be very good at that. You know that.
I know. And I expected that's what I'd get as an answer, but that's not an answer. I mean, here's the tenant who's saying, look, I have this ESA. I have this dog. Something happens with my dog. Let's say the dog didn't have to be removed from vet, but let's say the dog passes away. She gets a new dog. Would the landlord ask then for that? But they didn't, even in this case.
Not for a year later.
And then the question becomes, why did they ask a year later? Second thing is, under what authority did they ask that could affect this tenant's tenancy?
Well, as Mr. Herbeck had indicated, we didn't know about the dog, the Chihuahua, until long after she got it. It was seen.
But you're not certifying the dog.
I understand that.
If I get if you were certifying the dog and it was the status of the dog that grants that authority or that position of the tenant, I get that then. But you're not doing that. You're not even, what you're doing is you're certifying, or essence, asking for certification from the tenant. So at what point, and obviously there is nothing in writing, at what point does that expire? At what point does is the tenant obligated to do anything?
Let me pose an absurd situation.
Besides this one?
Yes.
Okay, go ahead.
Let's say the pit bull is removed and she decides to get a cow instead of a dog.
Okay.
Don't we have the right to question that as an ESA? Or do we? It's an absurd question. I can go hire an elephant or whatever. But we do have a right to review that situation.
I think you might have some justification if somebody had a dog and now has a cow. Or if they have a dog and then they get a tiger. I mean, I get that. But all I have, because at that point, though, your issue, the cow, and I'm not into answering hypotheticals, but your issue becomes that animal on our premises.
In part, yes.
Well, no, that's going to be, if it's a cow, I hope that's really your major concern.
Yes.
But in this case, it's a dog. And so it's not the issue of there being a dog. It's the issue of whether she needs an emotional support animal. But she's already answered the question, and the landlord doesn't have a procedure upon which they can make the request. Because the cold-hearted reality is, because of fair housing and other things, I'm telling you, Mr. Weiss, your client's going to be without a structure to it.
Without a what?
Without a structure to when they make the request or require the tenant to do something, they're placing themselves in a difficult position. Almost to the point, quite frankly, that I don't think you want to win this case because there's going to be a bigger fish for your client to fry.
With fair housing?
With the fair housing claim. because nothing's here. Nothing. Nothing the landlord is doing. First of all, does the landlord show me any contractual right exists for them to do?
Not that I am aware of. There's nothing in the pet agreement nor nothing in the lease.
At least you have to register now.
Yeah. In this situation, well,
But you're not,
That's
they
not
have
the
to
issue.
register the animal, but we're all in agreement that the animal isn't the issue.
in this situation, no.
Right. It's not the animal. It's her. It's whether or not she needs the emotional support animal. So, and then you're trying to charge her from back when?
October of 23.
Okay, so
This case has been going on a long time.
but this case has only been going on since May for
Yeah.
me anyway. But I don't see it. I just don't. I mean, if somehow or another the landlord were able to say, oh, let me back that up. What really has happened in this tenancy is the tenant has brought forth documents that place her in a certain status, right? Now, the landlord in that instance, as they have to do with many different things, has to have something in place that says, if X happens, if there's a change in status, or that at some point periodically you have to renew with us the fact that you still get the benefit of that status. Or this is how you lose that status. But can you get it back? If the landlord had something in place that said, okay, you get this status, and it's clearly not the case here, but you get this status with this animal. Upon the removal, death, whatever of this animal, then you have to renew your status.
Well, doesn't that
Then,
contradict what
okay.
you just said?
Pardon?
Doesn't that contradict what you just said?
No, I don't think it does. It only seems to contradict it because you're not really certifying the animal.
Exactly.
You're certifying the person. But those were hypothetical situations that I was giving just now,
Okay.
where the landlord could have certain things in place that then would require the tenant to do something, or require at that point, maybe even obligate the landlord to ask that you provide this information or whatever. But here, that's not what's happened. She gains whatever that status and the benefits of that status. There is nothing, I don't think, or nobody's shown me anything that changes that. That's the status she's in. The landlord then can't come along and say, oh, well, now you got to do this. Had the status, had everything attached to the pit bull, to the animal as opposed to the tenant, then I get it what the landlord's doing. Because now you have a new animal. Now I can ask about that animal. Not what happened here.
Can I ask a consideration? Whichever way you're going to rule, can you make it in a written opinion? Basing it on what you said in court today?
Well, I would,
in case my client wants to appeal it.
that's fine. I mean, I'll give an oral ruling. You can prepare whatever order you want. You can appeal away because the landlord doesn't have a status here. Or I could rule in favor of the landlord and then let you face the fair housing suit. Do it that way.
Another attorney has to worry about that.
But this issue,
No, I understand what you're saying.
somebody has, well, let me ask this then. Does the landlord have anything that forms the basis of their request to ask this tenant for that second doctor's note?
I'm not aware of it. Are you correct?
Well, as I said, she never did come forth to the office to register the animal. It wasn't until several months after she got rid of the pit bull and she was saw with this other dog. That's when we first made contact with her to register. Here we are today.
Did she register the animal?
Never, no. She has not
But
registered.
the animal isn't the issue.
I understand, but she still hasn't complied with the pet agreement portion. So therefore,
Which portion?
she signed a pet addendum for the pit bull. When the pit bull was removed, she never re-registered the Chihuahua.
Now the judge goes nuclear. You're not certifying the dog, you're certifying her need. So where's the lease clause, pet addendum language, or fair housing rule letting you demand a second doctor letter? Without structure, the landlord risks a discrimination mess. You don't want to win this, the judge warns.
Well, you didn't ask her to register the Chihuahua.
Yeah. Well, we did,
No, you didn't. That's not what you asked.
not in this particular case, but
Yeah,
as a
not
side
even,
issue,
you didn't ask her to register the animal.
not for the ESA purposes, but she still has to comply with the lease, which
But if
requires.
that's what we were here for, Mr. Wise, fine, but that's not what we're here for. I mean, I would absolutely agree with you with that previous scenario about the registering of the animal. But this issue is independent of the animal.
Right. But would we still have the issue if she registered the Chihuahua? Would she have to reclassify that as her ESA animal? That's one way you're looking at it.
Or did you ask her to do? But see,
We asked her to
hold on a
register.
second, hold on. No,
Okay.
because I'm not going to go down that path with you. Because what the landlord hasn't come in about the animal. That's not why we're here.
Well, yes and no.
No, because you're here because of her status.
Well, the case was originally started for non-payment of the pet fee and non-payment of the pet deposit. Was the basis of this particular lawsuit.
Right? But effectively, all of that was suspended in the
Was
best
it?
light for you, was suspended because she had an ESA and was in need of an ESA. But then at some point, which just doesn't seem to fit into anything logical, she's asked to renew that status. And I think the problem here, even if you had a time period of every 4 years, are there other individuals that you treated differently regarding that ESA? That's the dangerous.
I knew you were getting to that.
Yeah, because that's the dangerous waters that your client is in right now. And that's what I was saying at the very beginning, because if I rule for your client, I have a feeling they'd appeal, it'd go up, that would come right back to me for a specific finding of was she treated differently? And then your client's got a whole lot of other problems, the least of which is an ESA on this property.
Okay, so basically, if I can paraphrase your thinking, Your Honor, you're dismissing this case.
I'm not. I have, when Mr. Weiss, you know how I am. When I'm ready to do something, I'll tell you what I'm going to do. I don't know. I think as we've gone through this, I don't know that you need me to do it. The right thing to do would be for the plaintiff to dismiss it. And more importantly, then institute and formulate a policy by which you're going to handle these types of situations. Because and part of my reason for saying that is, even if I dismiss, I'm unclear as to this, but I don't know that alleviates the potential jeopardy for your client.
Well,
under fair housing, because it becomes the issue of not always am I successful in what actions I take, that I'm taking certain actions that may be in violation of that and or discriminatory.
yeah, but if the courts would dismiss it, or find no cause of action, let's say, and I would write in an opinion, or not opinion, prepare an order to that effect, setting forth your reasonings for that. That would be could be a basis if my client wishes to appeal. That's all I'm asking.
Oh yeah, that's what they want to do.
Yeah.
No,
obviously.
I don't really care, but
no, I understand.
I mean, I think there probably needs to be a discussion for you and your client as to where they're putting themselves.
That's a separate issue.
No, depending on what I do.
But if you dismiss it or find no, this is a hearing on the merits. If you find no cause of action,
well, but Mr. Weiss, I'm going to need to then take some testimony because there's going to be a question in my mind that I would have to resolve as to why this tenant why they made the request of this tenant. And I don't think you want my finding on that.
Can I have a brief recess with
my client? Court will stand in recess.
Till morning. I had a chance to discuss this with my client. At this point in time, we will dismiss the case.
All right.
With one proviso, which doesn't have to be put.
Of course.
I requested that the dog be registered, not calling it an ESA or not, just that they have to go in the office and register the dog.
But upon registering, her
status is not changed.
Okay. Ms. Bell?
Sir.
First of all, do you have any objection to the dismissal?
Providing they're gonna leave me alone.
Oh, I didn't ask you that. Do you have any objection to the case being? Okay, now, hold on, Miss Bell. Miss Bell, you said this so patiently before. You just wanted to yell at me, didn't you?
No.
All right. So then the next thing is that will you get the dog registered with them? That's not going to change your status, meaning everything's going to be like it is. They just want the dog registered, which probably is appropriate.
But Judge Simpson, we had actually given them a letter from Dr. McAvoy months ago.
When I first got.
Stating that the dog, that she's saying that he's supposed to have an emergency.
Hold on. I think that issue's over. Right? So
Well, he's asking me to send him an email from Dr. McAvoy.
I just want,
well, if you look, folks, they're looking to dismiss the case.
Mhm.
They didn't ask me anything about an email. The only thing that they're then asking is that you register the dog. And Miss Bell, you don't have a problem doing that, do you?
No, I can do that again.
Pardon?
I can do it again.
Did you already register the dog?
Yes.
we're not showing you.
You're not showing it registered, sir?
I checked it.
Oh,
Oh, okay. Well, whether you did it before or you have to do it,
I'll do
let's
it
get
again.
you'll get the dog registered.
Yes.
All right. Under those terms.
and the dismissal, Your
All right. Case
Your
dismissed.
Honor,
Yes, ma'am.
one thing, I just got out of hospital again, and this is my only transportation right here, because she's got to go back and forth to the doctor because she was in a car accident. So it's hard for me to get anywhere because I have to go on this. So could you just bear with me for a minute? Now, she said she's going to try to email her or whatever.
Okay.
Final seconds. Case dismissed, but the judge threads the needle. Register the dog within 2 weeks and her ESA status stays the same. Landlord retreats from fees, tenant agrees to register, and the judge keeps it practical. Like, comment, subscribe, and share, because this ESA paperwork war was wild.